Today on BenchBriefs, we're looking at a recent Supreme Court of Canada decision that deals with the delicate balance between law enforcement powers and individual rights under the Charter. The case is R v. Metzger, decided in early 2023, and it dives deep into when and how police can lawfully search a person's property and what happens when things go wrong. So, what happened in this case? The accused, Metzger, faced serious charges related to possession and trafficking of controlled substances. The police conducted a search and seized evidence they believed linked Metzger to these offenses. But Metzger challenged the search, arguing that the police did not have proper grounds or follow the required legal procedures. Essentially, he said the search violated his rights under the Canadian Charter of Rights and Freedoms, and as a result, the evidence obtained should not be allowed in court. At the heart of the case was the question, was the police search lawful? To answer that, the court had to look at several things. First, did the police have reasonable grounds to conduct the search? Reasonable grounds mean that the officers had a legitimate and supported belief that evidence related to a crime would be found. Second, did the police follow the rules set out in the criminal code, especially regarding obtaining and executing search warrants or authorizations? And third, if there was a charter breach, should the evidence be excluded to protect the fairness of the trial? These are fundamental questions because searches and seizures are powerful tools for law enforcement, but they also risk infringing on personal privacy and freedoms. The Charter protects Canadians from unreasonable search and seizure, meaning the police must carefully respect legal safeguards before invading someone's private space. In Metzger's case, the Supreme Court examined the entire process the police followed. They looked at whether the officers had valid authorization and whether their actions were reasonable in scope and execution. If the search was found to be unreasonable or unauthorized, then the evidence obtained could be considered fruit of the poisonous tree, meaning it should be excluded because it stems from an illegal act. The court's analysis also explored how to balance the need for effective law enforcement with the protection of constitutional rights. This balancing act is a key theme in Canadian criminal law, ensuring that police investigations do not trample on the rights that are foundational to a fair justice system. Why does this case matter? Well, R v. Metzger clarifies the standards police must meet when conducting searches, reinforcing the importance of adhering strictly to legal and constitutional requirements. It sends a clear message that evidence gathered through procedures that violate charter rights risks being thrown out, which can impact the prosecution's case significantly. For everyday Canadians, this ruling underscores that the Charter's protections are not just words on paper, they have real teeth. Police must respect privacy rights, and courts will scrutinize their actions carefully. For lawyers and law enforcement, it's a reminder to be meticulous in following the law because mistakes can undermine entire cases. In the bigger picture, Metzger reinforces the ongoing effort to strike a fair balance between effective policing and individual freedoms. It highlights that the justice system values both public safety and the rule of law, and that one cannot come at the expense of the other. Thanks for listening to this episode of BenchBriefs. Be sure to join us next time as we break down another important legal decision shaping Canadian law. Until then, take care.